Can rights exist without practical remedies? This video is for August 9th, 2026. Welcome to YesToHellWith.com. In the series on courts, constitution, and remedies, we have asked a simple question, a profound question. If the Constitution limits government, when do those limits actually protect the citizen? We have examined administrative tribunals, constitutional review, the framers' intentions, the constitutional oath, the office of sheriff, and the historical development of remedies. Today we bring those discussions together by asking perhaps the most important question of this entire series. Can rights exist without practical remedies? Think about that. The answer begins with another distinction. There is a difference between possessing a right and possessing a practical means of protecting that right. Those are not necessarily the same thing. Suppose the Constitution protects your property by limiting government. Suppose a public official exceeds the lawful authority entrusted to the office and your property is taken. Suppose you eventually prevail after years of litigation. The question is, did your right exist? Well, certainly. But has your right been protected? That is a different question. A theoretical remedy exists because the law says relief may eventually be obtained. A practical remedy exists because the citizen can obtain meaningful protection while that protection still matters. The distinction is enormous. A remedy that arrives after the injury has already been completed may compensate. It may correct. It may vindicate. But can it truly be said to have protected that right? If a citizen cannot afford the process, if the expense exceeds the value of the right being defended, if the delay itself becomes punishment, has the Constitution remained a practical safeguard against government encroachment upon that right? Or has it become a promise that exists primarily on paper? The framers understood that rights without protection are fragile. A written constitution alone preserves nothing. It depends upon institutions and public officials and a free people willing to insist that constitutional limits remain meaningful in practice. Otherwise, rights slowly become theoretical. They continue to exist in principle, yet become increasingly difficult for ordinary people to enjoy. This is not merely a question of law, it is a question of constitutional design. Did the framers intend constitutional protections to exist only for those possessing sufficient wealth, time, and endurance to pursue years of litigation? Or did they intend those protections to operate as practical restraints upon the exercise of public authority itself at the moment? The Liberty Dialogue system asks us to distinguish between theory and reality, between rights that merely exist and rights that are actually protected, between remedies that eventually arrive and remedies that operate when protection is needed in the moment. Those distinctions matter because if constitutional rights exist without practical remedies, then freedom itself gradually becomes theoretical. In our next discussion, we will examine one final question. If administrative government possesses institutions capable of immediate enforcement, what institution was intended to provide immediate constitutional accountability to transgressions of rights and freedoms of the people? That is where we continue the conversation. And as always, may truth reign supreme.